Commission resumes. We were asked to wait before commencing this morning so that some of Mr. Porfir's clients had an opportunity to be here. But he's now informed me that he has not yet arrived. Perhaps you could say something further on that so we can start in their absence.
Yes,
think they may well arrive while you're busy.
Yes, thank you very much.
Let's put that on record.
Thank you, Chairperson. Thanks for the indulgence. The reason why I was starting half an hour late is because I requested the commissioners in chambers to await my clients. We've just called them. They said they are not very far. They're crossing the last bridge. But unfortunately, I don't know which. Yes, too many rivers to cross for them, I think. So we have agreed that we should start if their arrival seems to cause any disruption, then we'll ask for a 5-minute adjournment. But hopefully, I'm going to ask my attorneys to make sure that they try and come in as quietly as possible, Chairperson.
Thank you. Now, what we're doing this morning is you're going to tell us orally what the relief is that you seek, as far as postponement is concerned. You're going to tell us what the facts are on which you rely. So this can then be transcribed, will in effect be the written notice of motion and the factual vermins upon which it rests. And we will then proceed with the evidence. That will be transcribed. I'm assured it will be available by 9 o'clock tomorrow, and then be given to the parties. And they will then have until Tuesday to respond. I was informed this morning that the Department of Justice wishes to oppose the application, so I stated that they were also to be then given a copy of the transcription of what you tell us. Mr. Mpofu, would you like to comment?
Yes, thank you, Chairperson. Yes, exactly as the Chairperson outlined, we intend to have the transcript, as it were, serving as the founding affidavit. So we'll make both the factual and the legal amendments. Chairperson, before we start, just a matter of housekeeping. Thank you for informing us about the Department of Justice. We'll consider our position as to whether they're entitled to oppose the matter in these proceedings, but that's another story. What we would like, Chairperson, with your leave, is maybe an indication at some stage, either now or at some stage, of who is opposing the application, because it might help us to tailor what we're going to say. At this stage, the only party that has indicated that it will oppose the application are the evidence leaders. They indicated so at the meeting of the 21st of August. As far as we know, all the other parties, at least obviously they're not bound by the positions they took in the previous application, but in that application they had indicated that they would abide by the decision of the Commission.
Chair, my instructions are to oppose, so Mr. Mpofu must proceed on that basis.
Chair, as far as our position is concerned, we will reserve our position until we've heard the application. We certainly will want to respond to it, but what formal position we take up will depend on what relief is sought, what the grounds are, what the facts are.
Into ibivela ngokuba izizathu sokuba siqale emva kwexesha uziveze lo mhlekazi uMpofu kokuba bekumele abantu abamele basendleleni bathi baphaya ngasebrishini ngoku kuthiwe makaveze ke amaphuzu azawubeka kuyo isicelo esakhe baze bakwazi ukuthi sibhalwe phansi zonke izinto ezizawuqalaselwa kuzawuvezwa ke namaqela achasene nesicelo afuna ukusenza.
Chair, we will similarly reserve our position until we've heard the application and the grounds of the application. Thank you.
Thank you. Does anybody else representing any of the parties wish to state at this stage already what the attitude of the party concerned will be?
As the chair pleases, it's Tandon Zonkota on behalf of NUM. We would also like to put forward our position once we've had the basis for the application, Chair. For now, we'd like to reserve our right. Thank you.
bavelile ke ababathi bachasene nesicelo azosenza abanye ke bathi bazawumela ukuvelela ontetho kuzothi emva kokubenza isicelo babachasene na ikanene bayayeka.
Thank you very much, Chairperson. Maybe it's appropriate to start with outlining the relief that would have been in a notice of application.
Effectively, you're going to read what would amount to the notice of motion.
Yes.
We've been given some documents. I don't know whether
Yes,
they're
I'll
from
refer
you.
to those.
One of them is the amended notice of motion
In
the High Court.
Yes.
Yes. That's been marked 1A.
1A, yes. No, we don't. Everyone has got this document. It's just cross-referencing. It's not. The others are just cases.
Take it you're not going to argue the application today, are you? You're just going to tell us.
Well, the basis, yeah. What I'll do, what I propose to do is not necessarily to argue it, but as one would do in an affidavit, you'd put factual and some of the legal basis, yes, yeah, without. Thank you.
Sorry to interrupt, Chair. The parties don't have copies of that. We will, once we've been given copies by the Commissioners, arrange to distribute to everybody.
No, sir. Yeah,
I will listen patiently to Mr. Mpofu, and I see Advocate Hemraj is ahead of me in proffering her copy. So her copies will be taken away, and extra copies will be made available to the evidence leaders. And anyone else who wants copies, will they please raise their hand?
it's just the amended notice of motion, which I'll read into the record. I don't think anyone needs to have a copy as such. And, or alternatively, they already have copies. We served it on everybody.
Anyway, you carry on. And copies are being made in the meanwhile. It doesn't prejudice anybody. And those who get the copies will appreciate it. So if the police want a copy, and the evidence leaders want a copy, anybody else? 10 copies have been made.
Okay. Okay, well, it's fine. Thank you then, Chairperson. I think that would cover then the issues of housekeeping. Chairperson,
I'm sorry, that 10, does that include the Human Rights Commission as well? You want a copy too, I take it?
Chair, what we are doing is we are making 10 copies, which will be enough to cover everyone who's here for the moment, and we're getting it scanned, and we will circulate to everyone electronically.
well, okay. But they already have the notice of motion, but that's fine. Chairperson, this is just one more housekeeping matter. I was asked to convey the apologies of my learned colleague, Mr. Ntsebeza, who unfortunately could not change his flight for his Bloemfontein engagement. His attorney, Mr. Musikidi, is here, but since he had promised, he asked me to convey his.
Thank you.
Thank you, Chairperson. Chairperson, this is an application for the postponement of the commission pending the attainment of funding, either from private sources or the outcome of the application for state funding, which has been set down for hearing on the 25th and 26th of September 2013, whichever happens first. I will therefore start by unpacking, as it were, these two events, the happening of which will mark the end date of the postponement period, of the proposed postponement period. Firstly, I'll talk about the outcome of the application, or the main application set down for 25 and 26 September. That application, Chairperson, in a nutshell, is for, I'm referring to the document marked 1A. And Part B thereof says the following. It's an application for an order in the following terms. 1, declaring the conduct of the first, second, and fourth respondents, that is the President, the Minister of Justice, and the Legal Aid Board, or Legal Aid South Africa, as it's called these days, in failing and or refusing to provide the applicants with legal aid in respect of the Commission proceedings unlawful, unconstitutional, and accordingly invalid. 2, ordering the first respondent, the first, second, and third respondents to take all reasonable steps to provide adequate, fair, and equitable legal aid to the applicants in respect of the future proceedings of the Commission on the scale or tariff ordinarily employed by the third respondent, in other words, on legal aid rates, including all reasonable costs incurred to date, less any amount received from third parties. The rest is just the usual prayers for alternative relief and so on. Those are the principal prayers, Chairperson.
Baveza ngaphambili umhlekazi Mpofu ba esisicelo asenza namhlanje sima yelana nantoni simaqondana nantoni njengoba ebeka nje kokuba bacela kokuba imiswe le commission kude kube leyo mina xa kuzokwenziwa eso siqhibo.
In other words, Chairperson, what is, if the Chairperson could just bear with me 1 second. Those prayers must be read in the context of what was said in the Constitutional Court in summing up the position at paragraph 2 of the Constitutional Court judgment, Chairperson, which says that the Commission, well, paragraph 1 talks about when the Commission commenced and so on. And then 2 says, to cover the legal and other expenses incurred by their participation in the Commission's proceedings, the applicants procured funding from a non-governmental entity, the Wraith Foundation. However, this funding was only secured for the 6-month period from October 2012 until March 2013. The applicants have been unable to secure funding for the period April 2013 until October 2013. Neither have they been able to secure contingent funding should the Commission's term be extended once again. That's the Constitutional Court summed up, therefore, in that paragraph, the position. In other words, Chairperson, we've unscientifically postulated that the Commission may be extended, let's say, for another 5 months, in which case it would last 18 months. That's just a working figure. If it does, what is being said is that the funding requested is for the 18 months minus the 6 months, which would be the 12 months. That's the period for which no funding has been secured and is being sought. The other issue that I would like to point out in relation to that application is that although some of the parties are cited as respondents, in reality, and in keeping with the posture they assumed in the Constitutional Court, in reality, the applicants are the injured and arrested, the deceased families, AMCU, the LRC representing the Ledingwane family, and the Human Rights Commission to some extent. And the practical arrangements in court were that those parties would be entitled to argue and reply as if they were applicants. Okay. Thanks. I'm told that the clients are here. Thank you, Chairperson.
Want us to take a short adjournment so they can come in?
Let's see how it goes, Chairperson. Let's see if it's disruptive. If it's not, we'll just carry on. Thanks.
Ubeveza umhlakazi Mpofu kokuba sezifikile izihlobane zalamani laba bamele abenzakalayo nababoshwa bakhona abaphandle.
Yes. In any event, I'll deal with the preliminary issues, Chairperson. So that's that's the other thing I wanted to bring into the attention of the court, of the commission, in relation to the application. The second issue is or second event, which may or may not curtail the period of postponement, is the attainment of funds from other sources other than the state.
Uthi kenye into ezaba khona ukuthi xa umbuso ingakwazi ukuba ibaxhase bangahle bamele ukuba kubekho abanye mhlawumbe abaxhasi abangaphandle
And Chairperson, in respect of that, we would submit that there are reasonable prospects of, at the very least, at the minimum, being able Yes, Chairperson, I think we have to ask for 5 minutes. Thanks.
We'll adjourn for 5 minutes.
make sethu thatha ixesha le 5 minutes xa kusangena i-families.
Yeah.
Commission resumes. Siyangena commission.
The commission resumes. I see quite a lot of your clients have now arrived,
Yes.
so we're able to proceed.
We'll proceed. Thank you very much, Chairperson, for
Futhi
the
umkhinihlalo bona
indulgences.
bafikile ngoku sizabe
There are problems with buses and so on, but they're here now. Thank you very much, Chairperson. Much appreciated.
yabulela umhlekazi Mpofu uthi kwaba khona ingxaki ngebhasi kodwa ke inkosi yabulela.
Chairperson, I was at the point where I was talking about the second trigger event, which is the attainment of funds. And I was saying that we believe, Chairperson, in the High Court we were always called eternal optimists, but we have to be optimistic when we are involved in this kind of struggle. But we believe that there are reasonable prospects of the attainment of funds, at the very least, for a quicker or speedier interim return, even before the hearing. That optimism is based on, as I indicated yesterday, firstly, the fact that the clients that we represent, the workers, the protesters, so eager are they to come back to the Commission that they themselves made a collection at the commemoration service using buckets that were passed around there, which I call their own version of the bucket system. And they collected, the exact amount is 17,201.50 cents. It came mostly in coins, and every South African coin was there, from 1 cent to the 5 rand coin. And my favorite part is that when the money was being counted, we found on top of this money $1 American and 1 maluti from Lesotho. So it means it has both an African and an international flavor in its collection.
Uyibeka ngolo hlobo Mpofu ukuba bazimisele nyani ukuba bekhona aba bantu bathi ngale mini ye-commemoration bahlanganisa imali eyayithela kwi-bucket laphayana kwabethwa imali engangamawaka angu-17,201 rand kukhona $1 yase-America nemaluti yakuLesotho.
And they did this in the name of assisting the effort for their lawyers to return to the Commission.
Yonke lento kuzinzame zokuba bayafuna uba ii-lawyers zabo zibe khona kule commission ngendlela abazimisele ngayo.
So, secondly, Chairperson, I know that they are busy trying to devise other ways of similar fundraising. But secondly, there are other more conventional ways of fundraising that have been initiated. Most notably, there's a new organization which calls itself Citizens for Marikana. Mr. Eric Derrida, who's sitting there, if you can lift your hand, comes from that organization. And they've approached us because they in turn have been approached by people from all walks of life and citizens and organizations who also want to assist in the effort to assist the legal representation of the victims.
Uveza umhlekazi Mpofu kokuba likhona ithemba lokuba ingafumana oluxhaso ngoba kukho abantu abenza inzame ezoningi ezohlukene njengomhlekazi uJeride phaya we-Citizens for Marikana naye uwenza inzame ezinjengezo.
And thirdly, there's always although I'm not holding my breath on this one, there's always the off chance that the government will come to its senses and settle the matter before the hearing. And a combination of those possibilities might see an earlier return than the dates postulated.
Nalo ke nethemba lokuba naye uhulumende uzawubuya ezingqondweni ancede okokuba iqhubeke lento ngendlela efanele.
Mr. Mpofu, when you talk about returning before the court date, what sort of periods are you looking at if you're talking about interim funding?
I'm sorry, Commissioner, I missed the second part of the question.
If you're talking about interim funding and returning possibly before the court date in the High Court, what sort of periods are you looking at? What time frames are you looking
Oh,
at?
yes.
kungafunyanwa imali phambi kwale date ibekiwe pha eHigh Court.
Thank you, Madam Commissioner. Well, it's difficult to say. I know for a fact that there's a public march that is being planned, which is also part of the fundraising effort. I'm thinking that by the time that happens, which I've been told is within a week or two, then all these things that I've mentioned would have been pulled together somehow and communicated to us. And if the indication is that there is enough for us to come back, we will come back. And I must indicate that as far as I'm concerned, it would mean covering costs of overheads and things like that, not necessarily the fees, because we've gone so long without fees. So another 3 weeks would not necessarily be prohibitive, because we also have to contribute. We have to contribute to, at least speaking for myself, I would contribute to the effort of coming back, even if my fees were not covered. So it's a couple of weeks at West.
Xesha uthi kuzawuba ziviki nje ezimbalwa phambi kokuba ilungele nto banethemba kokuba yelo ngagqithi ixesha elide naye ngokwakhe uzimisela kokuba eze apha noma engafumani imali eza kuyena.
But I think, Commissioner Hemraj, the importance of that happening would not only relate to the period, let's say, between that coming back and the case. It would obviously, even the period of awaiting judgment or whatever would have happened. So the advantage would be quite a profound one indeed.
Sathetha ngalo le kuba siza kukhutshwa nini isigqibo kule sicelo abasenzile kwinkundla ephakeme.
Chairperson, it was correctly pointed out and intimated by the Commission itself and by my learned colleagues, Mr. Bartland and Mr. Semenya, that this application is no trivial matter, but one whose outcome will have a profound effect on the complexion and texture and the credibility of the ultimate outcome of this Commission. We agree that this is not your conventional postponement application.
Mr. Mpofu, I understood you were just going to tell us effectively the relief you seek and the facts on which you rely.
Yeah, we're getting there.
Yeah, okay.
Uzawuza ngoku ke kwizizathu ezenza kokuba enze esi sicelo umhlekazi Mpofu.
I'm saying that it's profound simply because your unenviable task, Chairperson and Commissioners, will be to make a determination as to whether the Commission continues in the absence of the majority of the victims, or whether whether it is postponed to enable them meaningfully to participate in the Commission, which cannot be an easy decision.
Uyatsho umhlekazi Mpofu kokuba isigqibo esinzima kufanele sithathwe ngumgcinisileyo neekomishina zakhe. Into enzima lena kufanele enze isigqibo sokokuba uyayimisa nale commission ukuze aba bamelwe bakwazi ukuba khona jongo nesidima iziphumo ezizawuba nazo.
But I would like to venture to say that the decision you make might also have an impact as to whether at the end of the commission there is ground to suggest that an irregularity has been committed or not in view of a potential refusal and maybe even a granting, who knows.
Uthi kuzawuthi phaya ekugqibeleni ke kujongwe isigqibo oza kusenza mhlekazi okokuba sinentembeko engakanani kuye ngento kwisigqibo oza kusenza ngokuba uyayimisa nayo le nto kanene awuyivumelani nayo.
So the decision you take may or may not deal a fatal blow to the perceived credibility of the outcome. As the Constitutional Court put it, that the outcome would be compromised. This is what the Constitutional Court said. I know I've quoted it before. It says, ordinarily, a functionary setting up a commission, in this case that would mean the President, has to ensure an adequate opportunity to all who should be heard by it. Absent a fair opportunity, the search for truth and the purpose of the commission may be compromised.
Yathetha ngolo hlobo ke inkundla yomgaqo-siseko isithi xa kujunjwa ikomishini enjengalena lo ojumba leyo commission kufanele enze yonke into efanele okokuba onke amaqela alapho onelisekile ukuze kube nesidima sasigqibo esesithethwe ekugqibeleni.
Well, I'll come back to this point, but just to finalize what I would call the legal points, I'll just make the point that it is tried that the dominant issue in an application of this kind is the question of prejudice or potential prejudice to the applicants, or indeed to both sides.
Mr. Pope, I did say to you, I understand you're not arguing the application.
I understand that.
You're going to give us effectively the notice of motion, the relief you seek, and then you're going to give us the facts on which you rely. You're going a little beyond that at the moment. If this is by way of introduction,
it is.
I'll give you a little bit more leeway, but please don't take too much time with that.
Well, Chairperson, as I understand it, a founding affidavit is not just crudely composed of facts alone. It also sets out the legal basis for which the application.
You haven't got your founding affidavit yet. Yeah. You still, aren't you going to give us a notice of motion first? Relief you seek.
No, I've gone past that. Oh, I understand, Chairperson. No, I've gone past that. The relief, if I may repeat, is quite short. It says, the postponement of the commission pending an attainment of funding from private sources or the outcome of the application for state funding, which has been set down for hearing on 25-26 September, whichever happens first. That's it. I was just unpacking now that relief.
Yeah. Now you're giving us the funding affidavit.
Absolutely. Thank you, Chairperson.
Kwinkundla ephakeme esizokwenza ngomhla ka-25 noma 26 uSeptember kulo nyaka noma ke uxhaso olungahle lifunyane phambi kwalo mini.
I was saying, Chairperson, that the dominant issue is prejudice and convenience, obviously looked at from both sides.
Into sijongile kwangoku ukuthi makungenzeke okokuba kubekho ulahlekelo oluthize ngenxa yokungabi khona kwabo bamele amaqela athize.
So I'd like to start with that, Chairperson. But maybe before I do so, let me so that the Chairperson doesn't have to remind me again, just outline some of the facts, the crude facts, as it were. One is that
the facts, I suppose you should really outline all the relevant facts.
All the relevant facts, but some of them are obviously contained in what are semi-legal submissions, yes. But yes, these are the main facts. One, that we represent more than 300 persons who are described in the terms of reference either as falling under the category of injured, or which I think is estimated at 78 in the terms of reference, but the numbers are not important, and arrested, which in the terms of reference is again, estimated at about 250. The actual number is 272, but once again, the numbers are not.
Some of the arrested people, or possibly all of the injured people were arrested, were they? Or are
Not
there
all.
some?
There is an overlap, but it's not complete, Chairperson. Yes. That's why the number then jumps to over 300, yes.
Inani labantu endibamele apha lichitha amakhulu amathathu bantu ababonzakala phaya nabo ababanjwa.
Yeah. And then, of course, my learned colleagues represent mostly the deceased families, which, so you'd say the number is probably, that we're talking about, is probably just more than 350, give or take.
Abamelwe ngumxawami lona umhlekazi usebenza bazizalamani nezihlobo zalaba basweleka bangaphezulu
Deceased families are, I understand, receiving legal aid. Is that correct?
They are, well, not adequately. I think, Mr. I don't want to speak to them. Some legal aid.
Adequacy is not another matter.
Yeah.
But they did make an application to the Legal Aid Board, and they were granted legal aid.
They were granted some legal aid. Mr. Nsebeza explained it in detail on the 26th of
There may be
February.
debate about the adequacy.
Yes. 26th of February, the transcript would assist you, Chairperson. Mr. Nsebeza outlined it. But in any event, the point is that there are applicants now to this postponement application. That's the point I'm making.
Kukho abafumana uxhaso oluvela kwa-legal aid kwifamily ezizimele ngumhlekazi usebenza uthi kodwa ke bangabanye babantu abenzile.
Why, will the High Court then be called upon to decide to what extent the legal aid which has been granted to the families is inadequate and falls short of what should be granted, and then make an order in respect to that? Because I don't see that in the notice of motion.
No.
Chair, Dewa Musikiri from Seri. I represent the families of the deceased. Chair, just to clarify the position, the families are indeed funded by the Legal Aid Board, and as much as we are applicants in the High Court, or at least we are applicants in the Constitutional Court, and we are supporting the High Court application, it is not our aim to seek a relief to review the equality of arms or the adequacy thereof or lack of adequacy of the current fund that's been provided. It might be something that comes along the line, but it's certainly not our relief at this stage.
Relief sought only relates actually to the people who have been described as the injured and arrested minors.
Yes, Chairperson. That is correct.
The families are applicants. I'm not sure whether they've locus standi to apply, but that's not a matter that I have to concern myself with. They're only applicants on a sort of solidarity basis, if that's the correct word one can use. Is that right?
Chairperson,
for a lack of a better word, yes, we can resume with that word, Chair. Thank you.
Yes.
Uyavuma uTebu okokuba iifamily zona zinalo uxhaso oluvela kwa-legal aid into nje baxhasa esi sicelo esenziwa ngaba bonzakala nabo ababanjwa kokuba mayime le nto.
Chairperson, maybe for the sake of completion on that point, my understanding, subject to what my learned colleague would say, is that that is also the position of AMCU, which is an applicant, but in solidarity, as the Chairperson explained it. The only distinction is that the deceased families, and I'm sure Mr. Musukidi will deal with that, have made what I think is a profound statement in their own papers of saying that because the people that they represent are deceased, they rely for their own closure and knowing the truth on the testimony of the survivors, namely the injured and arrested. And that without the participation of the injured and arrested, their own participation would be meaningless. And they've made that statement.
Ithi ifamilies yezachaza kokuba ngoba zona bezingekho apho zifuna ukuva ngaba bantu bonzakala nababanjwa ukuba yintoni inyani eyenzeka phaya ngoba inyaniso iyawuvela xa bekhona aba bonzakala nababanjwa xa bengekho inyani ayinokuphuma.
Thank you, Chairperson. Thank you for seeking that clarity.
We've got clarity now.
Yes, yes, at least so that the facts...
made the point which I hadn't even thought of asking you, but I should have. What's the position of AMCU, but you've explained that.
Thank you, Chairperson, yes. So that's fact number one, so to speak. The applicants that I represent, as you know, Chairperson, just for the record, are represented by one advocate and assisted by attorneys whose number varies from time to time. But we come from what we call the triumvirate of law firms. That's all explained in the papers. The third issue is that, or rather fact, is that the main dispute in these proceedings, there are many disputes, so I don't want to be drawn into that. But the overriding dispute is whether or not these people that we represent and that they represent were killed or injured by the police in self-defense or not.
I think it's actually self or private defense.
Self or private.
That's
Correct.
effectively the only defense raised by the police.
That's correct, Chairperson. Yes.
Lento esijongene nayo kakhulu okokuba kuvele inyano okokuba aba bantu sibamele abenzakala nabasweleka inyaniso na okokuba amapolisa enza esisenzo ezikhusela noma ekhusela ogaba.
Thank you, Chairperson. Yes, self or private defense. The other fact is that at least the version of the people I represent is that they are calamities, of whichever type, were caused by a toxic collision between SABC and lawnmen. That's their version.
Abantu bamele ke bayiveza ngokucacileyo kokuba babona lento kwabakho ukuhlangana kwemiqondo okunotshefu phakathi kwelonmini namapolisa.
And that those parties in combination are represented by about 12 advocates.
Bathi ke into evelayo okokuba ezo lawo maqela amabili ane advocate ezengu-12 bona baneyodwa.
The next fact is that the witness who's testifying at present, General Mpembe, is easily the most important witness in that he was the overall commander of the operation that led to the massacre.
Elingqina likhona ngoku apha uGeneral Mpembe ngokujonga kwethu ke ilona nqina elibaleke gqitha kuyo yonke lento ngoba nguye wayengumphathi jikelele wayo yonke lento eyenzeka pha.
Fact number 6 is that the evidence leaders are currently cross-examining that important witness, purportedly to put, among other things, the version of the people that we represent.
Vekuthiwa aba lethu ubungqina ngaphambili babuza imibuzo ngoku inzame zokuthi baveze izinto ezithethwa ngaba abonzakala naba abanjwa.
Fact number 6 is something that we've already covered, which is that the matter is set down for the 25th and 26th of September.
Enye ke into kokuba sesifumene i-date yange-26 ne-25 kaSeptember apha kuyokwenziwa khona isiqibo.
Fact number 8 is also a matter that we've just covered, namely that the applicants that I represent with at least 2 other parties have provisionally withdrawn from this proceedings.
Mandisho kuba abanye ababini amaqela amabili asezidonsele emva rhoqile kuluphando.
Fact number 9 is also a matter that we covered when we were dealing with the relief, which is that there are fundraising efforts which may yield to earlier temporary relief.
Enye into esesayiveza kokuba kukho ithemba lokuba kungahle kufumaneke olunye uxhaso phambi kwale mini ndithetha ngazo.
Fact number 10 is the issue we covered yesterday about possible or alleged ongoing harassment of witnesses.
Covered it yesterday, but I'm not sure it's necessarily on the record unless you just want to refer to the transcript of what you said yesterday.
Oh yes, thank you, Chairperson. Yes, you're quite correct. So that this one is compact. Yes, thank you, Chairperson. That matter, in a nutshell, related to the arrests, a wave of arrests that have taken place since last Thursday, which involves about 10 people, 5 of whom have already been arrested and released on bail, and 5 of whom are actually, as we speak, 2 of my attorneys are not here now. That they're doing the making the bail applications of the other 5 right now.
Ngitente ndayiveza ke zolo kokuba kukho kokwezola olukhona 10 yabantu abayini bamele ba ngenele ngamapolisa i5 yabo iphume ngebail kwangoku njengoba nithetha nje abameli baphaya bacela ibail yabanye abahlali.
And the only relevance of that to you, Chairperson and Commissioners, or to this application, is the fact that all those bail conditions, just like the one of the 272 accused, have been held over until the completion of the commission.
Mandisho kokuba yonke lento eyenzeka ngoku iyafana nakula 272 eyaphuma kuthiwa ke imiqathango yebail izawugcinwa ime kude kugqitywe le commission.
I'll find it later. But that fact should be viewed in conjunction with the wording of phase 1 in this commission, which among other things seeks, I'm paraphrasing because I don't have it at hand now, seeks to determine, if I may just, Chairperson, I think it's better. Yes. Thank you, Chairperson. Phase 1, you'll remember, I'm reading this from the affidavit of the Human Rights Commission in the papers, where they quote phase 1. This is what the Human Rights Commission says. The 16th respondent, which is them, is also of the view that the applicants are entitled to proper legal representation before the Commission. This view is based on the fact that the Commission is investigating the applicants and their actions during the week 9 to 16 August 2012. This view is made even stronger by virtue of the fact that the Commission has made a ruling on the scope of phase 1 of the proceedings before the Commission to include, quote, 1, an investigation into whether participants in the crowd of protesters at Vonderkop on 16 August 2012 should be held criminally liable for the death of 34 of their fellow protesters and or in respect of the alleged attempted murder or assault of SABC members at the scene. And 2, the direct causes of and legal responsibility of any party for the deaths and injuries to any persons and damage to property at Marikani during the period 9 to 16 August 2012.
Ndibeka lento ngaphambili njengoba iveza ihuman rights okokuba aba bantu abalishumi nesithandathu baphandwa ngezehlakalo zemhla ka-16 okokuba batshola ngokuba nabo bayimbangela yaba bantu abasweleka abangu-34 bangela yabantu abonzakala phaya ekuhlaleni nokulinyazwa kwempahla yabanye abantu.
At the risk of stating the obvious, we are currently busy with that phase 1, which will determine, among other things, the things that I've just read out.
Njengoba iCommission apha koluphando ngokulokuqala zezinye zezinto ezijongwayo kokuba aba bantu bafanele na ukuba kuthi ekugqibeleni kube ngabo abatsholwayo.
And therefore, we say that the terms of reference, or rather, the phase as described, deals specifically with the criminal liability of the injured and arrested, or rather the arrested mostly, and some of the people who have now been arrested, subsequently arrested. Fact number 11 is that what we call the state parties of the government is of the view that there is no need for the legal representation of the applicants, while the state intends to keep its own representation by private lawyers.
Uthi ke into exakayo kokuba umbuso uzimisele kokuba wona ube namagqwetha omele kwelinye icala uthi aba bajongene nabo abanagunya lokokuba bafumane abameli abaxhaswa nguwo.
And then lastly, in this dozen of factual amendments is what I call some of the statistical issues or the figures. We know now from what the Minister of Justice said last week that the state has proposes, on the assumption that the Commission will finish at the end of October, which we know is not going to happen, has made a provision of some 115 million rand to be spent on the Commission, made up as 32 million rand in the year 2012-2013 and a further 83 million rand in the financial year 2013 to 14. And that includes the money that they spend on legal representatives.
Unthi ke uyivile intetho evezwe ngumphathiswa kule viki egqithileyo ukuba xa iCommission lena izawugqitywa ngo-October njengoba kubekiwe banayo imali ezizigidi ezingu-115 million ezawukhokhela zonke indleko nezabameli kude kube elo xesha. Sazi kakhulu ukuba ayinawuphela ngelo xesha liCommission.
And that it was made clear that in that amount of 115 million, there's no place for the assistance for the victims.
Wayiveza ke kabanzo kokuba kule mali ayibalile ayikho ebeyibekwele kuqala okokuba incede ababonzakala nababanjwayo.
Or to be fair, I think it was no place for the victims who were not in the employ of the state.
Abo bangasebenzeli umbuso.
Secondly, because of the already skewed nature of the representation, the estimates of what has been spent on legal representation, which was submitted in the Constitutional Court at least and not contested, is contained at the last page of 1A in front of you. Check this. And according to those estimates, and it's worked on a rounded 20-day month, the applicants that will represent the injured and arrested, and these are figures just for what would be advocates' fees. For such a 20-day month, at legal aid rates, obviously, the cost for the one advocate who represents the applicants would be about 340,000 rand. And the estimate that is given for the monthly spend for SABC is 3 million rand. The estimate that's given for the monthly spend for loanmen is 2 million rand. And the estimate for what is spent on the evidence leaders is about 3 million rand per month.
Ibeka ngolotho umhlekazi uMpofu kokuba illegal aid yona ibeka kokuba ngenyanga kwaba ebaxhasa ikhipha 340,000 kanti ke 30 million ekhutshelwa abanye abamele amapolisa kube 3 million kube 2 million ekhutshelwa abanye 3 million ekhutshelwa abanye.
Based on the current lifespan of the Commission, which will end at the end of October, which should be a 13-month lifespan, the spend on the first applicants it would be 4.4 million. On SABC, it would be 39 million. Loanmen 24 million, evidence leaders 39 million.
Beka ngobohlobo kokuba xa kubekwa lonke ixesha okoyaqala se umbuso ukhuphe malini ekhokhela aba bantu ezimillion.
And based on the 18-month lifespan, which is more realistic, if there's going to be an extension, the breakdown would be for the applicants 6.1 million, for subs 54 million, for loanmen 36 million, evidence leaders 54 million.
Uthi izimillion ezakhutshelwa abo bantu ke xa i-commission lena ingathatha izinyanga ezingu-18 njengoba sicinga.
And those figures might not be exactly fitting with the 115 million that has been admitted by the minister, but they are more or less in line.
Zinoko zingahambelani nale 115 million uminister umphathiswa athethe ngayo.
Of course, we accept that in the 115 million there are other costs of running the commission.
Ndiyayamkela ke into yokuba phaa kule 115 million kukho ezinye izindleko ezingaphandle.
And then the breakdown of the number of advocates, as it standard, those representing the applicants that I represent, 1 advocate, subs 7, loanmen 5, evidence leaders 7.
Thi bona aba bantu bamele nguye i-advocate eyodwa ubebala amanani alama.
Oh yeah, Mr. Madanga.
Since the elevation of Mr. Madlanga to the Constitutional Court, it's now down to 6.
Yes, well, 6.5. 6.5. At least he was here for until the 1st of August, but I accept that correction.
Ubebale nomhlekazi uMadlanga lo sehambile ngoku
As far as the
sejudge
relief
phaya.
you seek is concerned, it relates to the future, not the past. It would be 6. But anyway, presumably that's a matter the evidence leaders will deal with.
Taken into account,
It doesn't
yeah.
affect the principle.
No, it doesn't. But I concede that point, Chairperson. In terms of the seniority, we've said that the number of silks or recommended silks, or someone at the back calls it silkworms, which are the people who have been recommended for silk but are awaiting the judgment. 1 for the first applicants, 4 for subs, 3 for loanmen, and 4 for evidence leaders. Or 3 now that Mr. Matlanga is not here.
Bhala kokuba yena uyedwa phaya kodwa ke lamanye amaqela.
I see you included recommended silks. have you? So
Yeah,
where you
that's what I was explaining.
That's where you get the 3 from as far as the evidence leaders.
That's correct. The silkworms. That's what we call them at the bar. They're neither butterflies nor worms.
Aba bebaveza ngoku zi-senior council ezimele lamanye amaqela 1, 4, 3, 3. Bese bakhona aba bazawungena ngoku kwisilk seba.
Thank you, Chairperson. So that then, Chairperson, circumscribe the 12 main factual basis for the application.
Ezike zizathu bezibeka ngaphambili umhlekazi uMpofu okokuba zizizathu ezinikezwa okokuba esisicelo i-commission sokuba iyimele nto ike ijongisise.
If I may then return to the matter of let me put it this way, the possible effect of not granting the postponement, which is the same thing as saying what prejudice could be suffered by either the applicants or the public in general.
Xa sesijonga ulahlekelo oluzawubakho xa i-commission lena ingavumelani nesi sicelo ndisenzayo.
Chairperson, it has been said that an application, or rather, let me put it this way. My starting point will be that this is effectively a sui generis kind of postponement application, because there's a lot of law on applications for postponement based on seeking legal representation. And that's really what this is. It's a postponement for a postponement while the applicants are seeking to assert their right to legal representation, which right, by the way, is enshrined in the terms of reference, term of reference number 8 of this commission.
Uthi esicelo asenzayo ke akusosicelo esiqhelekile nje sisicelo esingavamisanga ukuba senzeke kodwa ke noma kunjalo sibhaliwe sikhona pha kwimimiselo yale commission.
In numerous, too numerous to mention cases, it has been found that the right to legal representation or the refusal of a postponement based on an applicant seeking the right to legal representation may amount to a gross irregularity which undermines or vitiates the proceedings per se.
Kaningi vela ke lento kaninzi vela lento yokuba ukunqatshelwa ithuba lokuba umuntu azifumanele ongamela kuvamisa ukuba kubangele ulahlekelwa kulowo muntu onqatshele eso sicelo.
And that is covered in very briefly in what I've given you as case number 1, which is the judgment of Plasket J in S versus Lusu, where he said, just to summarize at the end, in these circumstances, I'm of the view that the accused's fundamental right to a fair trial was infringed by the dismissal of his application for a postponement to allow him the opportunity to apply for legal aid. That being so, the proceedings that led to the conviction of the accused were irregular. This irregularity is of such a nature that it vitiates the proceedings per se. I'm sorry, I'm reading from paragraph 19, the very last.
Ufunda phaya umhlekazi uMpofu isigqibo esenziwa okokuba lo muntu wafunyana anetyala akusetshenzanga ngendlela efanele ngoba akanikwanga ithuba lokuba azifumanele oza kummela we-legal aid.
In other words, the risk, obviously, that was set in the context of a criminal trial, but the risk, fairness is fairness, it doesn't matter whatever it is. The risk of vitiating the proceedings themselves looms large when one is considering the question of a postponement for the purposes of obtaining legal representation. So, and yeah. And in relying on that, one of the passages relied on came from England in the case of Gideon versus Wainwright. No, actually it's the US, a US decision of the well-known Black J in Gideon versus Wainwright, who said that, I'm reading against letter E at 542, similarly there are few defendants charged with crime, few indeed who fail to hire the best lawyers they can get to prepare and present their defenses. That the government hires lawyers to prosecute and defendants who have the money hire lawyers in criminal courts are necessities, or rather hire lawyers to defend, are the strongest indication of the widespread belief that lawyers in criminal courts are necessities, not luxuries, and that can be postulated to proceedings of this kind. The right of one charged with crime to counsel may not be deemed fundamental and essential to fair trials in some countries, but it is in ours. From the very beginning, our state and national constitutions and laws have laid great emphasis on the procedural and substantive safeguards designed to assure fair trials before impartial tribunals in which every defendant stands equal before the law. This noble ideal cannot be realized if the poor man charged with a crime has to face his accusers without a lawyer to assist him.
On the retrial, Mr. Gideon was acquitted.
Well, that's the specter that one doesn't even want to, as the saying goes, too ghastly to contemplate, Chairperson.
Ubefunda phaya umhlekazi uMpofu isigqibo esenziwa kwenye yekhotho zaphesheya kolwandle eEngland okokuba igunya lokuba lo muntu abe nommeli into efanele ngaphansi komgaqo siseko welizwe.
But the very two quick points that I want to make about that is that, as I said, fairness is fairness. But in the particular case of the people I represent, it must always be remembered that their own criminal liability is at issue. One, they've already been arrested and accused, and therefore they are not, ordinary participants.
Uthi into ebaluleke gqitha ke kwaba bantu ndibamele ubuninzi babo ngabantu esebabekwe amatyala ezenzo ezithize ekufanele bayojongana nawo ekugqibeleni into ke ibaluleke kakhulu okokuba babe nommeli kwangoku.
The next point, Chairperson, covers both the point I've just made, but also the point of, because really the issue is this, Chairperson. I think it's common cause, as we had a discussion yesterday, that the continuation of the commission under the present circumstances is something that's not ideal. That goes without saying. So the question is not so much whether there's prejudice or not, because there is. It's patent. I mean, anyone just has to look at Mr. Makidwan, and if you say, here I am standing with 7 bullet wounds, is it prejudicial or not that a commission about that fact should continue in my absence? Clearly it is. So that goes without saying. The question is whether the measures that the commission seeks to implement in the meantime would serve to cure that blatant prejudice.
Into nje esobala okokuba ukuchubeka kwale commission ngaphandle kwaba bantu bamele ayiyonto enhle kubanga ulahlekelwa manithatha umuntu onjengoMagidi1 onembumbulu ezingu7 apha ezayongena apha emzimbeni yakhe ingachubeka kanjani icommission enjengalena engekho yena kuthethwa ngayo.
And so that specific question, Chairperson, and it's a matter I touched on yesterday about the fairness or otherwise of presenting or representing or presenting a version of someone with whom one has not even consulted. That was dealt with in the case of Siheri, which is number 2 of those cases, Chairperson. That case dealt with the issue of the irregularity, but more specifically relevant to the measures. It said the following. I'm reading from page 36, from the letter C, and you'll pardon my accent. It says, ek het reeds gemeld dat nie een van die appellante die staatsgetuies ondervraai het nie. En dat nie een van hulle getuienis afgelê of getuies geroep het nie. Daar is geen aanduiding dat hulle versuim in hierdie opsig aan iets anders toegeskryf kan word, nie dan dat hulle, toe hulle hulself onverwags sonder hul regsverteenwoordiger bevind, aan wie hulle hul verdediging toe vertrou het, nie voorbereid was om hul eie verdediging te behartig nie. Onder hierdie omstandighede was hulle klaarblyklik ernstig benadeel en dit regtigheid inderdaad nie geskied nie. Die appel moet gevolglik slag.
Uyibheka ngolo hlobo umhlekazi uMpofu ngeAfrikaans kwityala likaSeheri. Ityala likaHeri laliphambi kwenkundla ephakeme apho kwafumaneka okokuba ukungabi nabameli kwabo aba bantu kwaba yiyona imbangela ukuba bangakwazi ukuzithethela phaya bafunyanwa benetyala yabakhupha inkundla ephakeme.
Okay, well, Mr. Shozi is dead to ask me to paraphrase. What is being said is that the... Thank you, Chairperson. I was going to do it in Setswana for you.
I already mentioned that not one of the appellants questioned the state witnesses, but not one of them gave evidence or called witnesses. There's no indication that their failure in this respect can be attributed to anything other than the fact that they found themselves unexpectedly without their legal representative to whom they had entrusted their defense. They were not prepared to conduct their own defense. Under the circumstances, they were clearly seriously prejudiced, and justice accordingly did not take place. The appeal must accordingly succeed.
Thank you. Yes. And thank you, the Chairperson. That's not all of us come from Cape Town as the Chairperson. But
are you going to want to interpret that into Xhosa?
I did.
You did? I see.
Yes, very briefly.
Thank you, Chairperson.
And Mr. Mpofu wants to interpret it into Tswana.
Chair, that is an idle threat, which I wouldn't be able to carry out. Chairperson, yes, the relevance of that, of course, is that what was being said here is that these were people, the appeal here succeeded on the basis that all the proceedings had to be nullified because the lawyers on whom these people had entrusted their defense, so to speak, had not been able to represent them. And as a result, they were not able themselves to cross-examine or ask any questions of the other side, so to speak. So one can, sorry.
Njengoba ndibeka umhlakazi uMpofu beyiphinda ke lento kuba phaya kwityala elikaSeheri laye lachithwa phaya enkundleni ephakeme ngezizathu zokuba xa bevela phambi kwamantyi phaya babengenabo abameli ababamele ngako ke ukohluleka kwabo ukuzithethela phaya kwaba imbangela ukuba bafunyane benetyala inkundla ephakeme yalichitha ke elo tyala.
The last one, Chairperson, is case number 3, and that's State versus Yelani, where His Lordship Mr. Van Rensburg J said, and once again I'll just paraphrase, firstly he relied on page 806 against letter G, he relied on the following extract from the case of Mtetwe. Firstly, he started with the Seheri case, which I've just read out. And then relied on the Mtetwa case, which says, quote, every person is entitled to obtain for himself legal representation at his trial and should be afforded an opportunity for doing so when it is reasonably demanded. It's obviously the last part that's important, asking for an opportunity for doing so when it is reasonably demanded. And then I jump, Chairperson, to the following page, which is more relevant to this application. Unfortunately, the letters are not clear, but let's say against the letter C on the other side of the page, where the learned judge says, the result of the finding that the appellant was entitled to a postponement is that it is not necessary to consider whether the sentence imposed on the appellant was a proper one, for the entire sentence will have to be set aside and the matter remitted for another magistrate for the question of sentence to be considered anew. In other words, what they were saying is that once a postponement was refused for the opportunity to obtain legal representation, it was not even necessary to look at the outcome of the proceedings. All the proceedings themselves were just tainted irretrievably by that refusal of the postponement.
Umhlakazi uMpofu apho befunda isigwebo esenziwa nguJudge Van Rensburg kwityala likaYelani apho athetha khona ngeli likaSeheri nelikaMthethwa okokuba igunya lokuba nomuntu okumele ligunya elibekiwe elifanele ukuba khona. Apha wathi asinawujonga nesohlwayo sizalichitha lonke elityala ngoba lo muntu akanikwanga igunya ebenalo lokuba afumane umuntu oza kummela kweli tyala.
And moving towards the end of the founding affidavit, then, Chairperson, I would say that in the...
Sorry, Mr. Mpofu, every now and again you raise your two hands in the air and you make
yes.
what amounts to quotation mark signs. Those, of course, won't find their way into the transcript. So I suggest if you want to do that, you should say quote, unquote.
Quote, unquote, or so-called.
Or whatever.
Yes,
rather than make gestures which the transcribers won't see when they transcribe.
I accept, Chairperson. Thank you very much, Chairperson. The point I really wanted to make is that I've already made the point about prejudice. as these matters are determined by looking at then counterweighing that against the other prejudice that might be suffered by other parties. Now, it's undeniable, Chairperson, that a postponement would itself. What time is it? Okay. It's undeniable.
Mr. Prof, don't interrupt you unduly. I'm proposing to take the adjournment at some stage shortly after 11. But I don't want to interrupt you at this point. Tell me when it is appropriate for us to take the adjournment, and we can then adjourn.
Yes, Chairperson, this would be a natural place because these are, as I say, the kind of concluding remarks.
We will take the tea adjournment, which I hope will be not longer than 15
Thank
minutes.
you, Chairperson.
That's good.
Mr. Prejudice.
Yeah. No, we're just going to do our side. Nobody is going to. Yeah, we'll finish up and we'll go.
Commission commences.
The Commission resumes. Mr. Mpofu.
Thank you, Chairperson. Chairperson, before I move on to the last few points, just want to read out very shortly some of the extracts from Tutoy's commentary on criminal procedure. One says at page 22.28b, dealing with postponements which are dealt with in section 168 of that act. 22-28b, big B, capital letter B. Yeah, thanks. The first sentence, really, says, an adjournment will normally be allowed to enable an accused to obtain legal representation. And then a few cases, including Siheri, is quoted. I jump to the next paragraph, which says, a failure to grant any postponement at all to enable the accused to obtain legal representation may lead to the quashing of a conviction. And then a whole lot of other cases. It's in line with what I've already said. And then, more importantly, on the what one might call the remedial attempts at remedial measures, it's on the next page, 22-28C, relying on a case of Beyer versus Director of Public Prosecutions, Western Cape, 2003, 1 SACR 164 Cape. It talks about that case, but the relevant part, it says, in that case, Selikovic J indicated that the idea of being legally represented cannot simply mean having someone stand up and speak on one's behalf. Representation entails that the legal advisor will act in the client's best interest and will say all that needs to be said in favor of the client. This involves calling such evidence as is justified in the circumstances in order to put the best defense before the court. The court then referred with approval to State versus Yelani, which is, I think, case number 3. It was held that the applicant was deprived of effective legal representation. The conviction and sentence were set aside on the ground that the applicant did not have a fair trial.
Njengoba sipho umthakazo Mpofu befunda kwimibhalo ebhalwe nguTutoy apho ebeka khona lento yokuba umuntu unegunyanyani lokuba afumane umuntu ozokummela etyaleni uthetha ngawo lamatyala oSeheri nalawa amanye okokuba ukunganikwa igunya lokuba umuntu afumane ummeli azikhethele yena ozawuthetha yonke into ayivezayo nokubiza amangqina afanele elo tyala ligqilela ngokuba lilahliwe zinkundla eziphakeme.
So to transport that to this case, it would simply mean that with due respect, the evidence leaders are not in a position to present the interests of the clients, because through no fault of their own, they would not be able to do what Selikovic says there, of being able to present all that needs to be said.
The person whose cell phone went off, please must turn it off. Everyone else must turn their cell phones off. Now the cell phone goes off, I'll ask the owner that the owner of the cell phone leave the room.
Ukuthi xa uphethe iselfone uyivale iyaphazamisa xa uphethe iselfone iphindilile sisacela ukuba uphumele phandle.
Thank you, Chairperson. That then rounds off that point.
Ugqibela apha umhlekazi Mpofu kokuba ababazisa ukunqina ngaphambili akungabo abantu bafanele ukuba bamele aba bonzakala nababoshwa ngoba akuyo abanawuveza yonke intetho yabantu njengoba bafuna ukuba ivezwe.
And when we went to the break, I was at the point where I was saying, Chairperson, one is obviously dealing with a weighing process here it would be silly for me to deny that the granting of the postponement somehow will cause some general prejudice to others. I think that goes without saying. The question is which prejudice should prevail, really, in terms of the impact thereof in the larger scheme of things. Yeah. Now, one of the tempting things, of course, is what I call, the bane of modern society is short-termism. So it might be tempting to want to finish, get on with it and all those important things. But the danger of that approach is that where you might have paused for a couple of weeks and maybe save the whole process, we may proceed in haste, which is understandable, and cause irreparable damage.
Uthi into ekhona kulezi nsuku kukho lento yokunqama kokuba singxame ukuba senze into siyigqibe ngexesha elithize kuthi ekwenzeni njalo ke sibangele ulahlekelo lwamagunya abanye.
So we might be faced with a choice between, as I say, tempting instant gratification of reaching the finishing line, between that and the real achievement of sustainable, lasting peace, accepting that justice is by its nature a very slow animal. That takes me, that takes me to 2 points.
Mr. Mhlongo wanted to interpret what you said
Yes.
about the slow animals.
Thank you, Chairperson. Yes.
Very briefly, ubethi umhlekazi uMpofu apha ke kubulungisa akufanelanga ukuthi into siyenze ngogxama masiyenze ngendlela efanelekileyo.
Thank you. Mr. Mhlongo and I had a private deal before we started. But I was saying, Chairperson, Mr. Mhlongo and I had a private deal before we started, but we were both not implementing it at the right times.
It's true. So I had said I would try not to.
Where I can bear them in mind, but if you don't tell me, I'd have to do the normal rules.
Thank you. Yes. Yes, we won't ask for it to be made a ruling. That, Chairperson, takes me to two very, very, very important points about the prejudice to the general public interest. And I'll take it beyond what I said yesterday about the cost of sitting in the commission and all that, to what is really crucial. And it is this. We have always to remember that when all is said and done, and one has gone through the terms of reference and so on, the purposes of this commission can be reduced to two crucial things. One, it is to establish the truth of what happened during those fateful days, which is important and in which the people we represent have an obvious interest. So I don't have to belabor that. But the second one, and maybe even more profound, is to ensure that something like this never happens again. That second aspect is sometimes, because even in this debate about representation, the issue of the truth is obviously one that lends itself to that debate. And sometimes people forget that the second aspect of ensuring that this doesn't happen again is equally, if maybe not more important, in the sense that we cannot bring back the people who died, but at least we can ensure that this never happens again.
Uyiveza ngolo hlobo umhlekazi uMpofu uthi xa sijonga yonke into ejongwe ile commission noma sesijonga phaya kwimimiselo yayo into efunekayo ukuba inyaniso ivele okokuba kwenzeka ntoni phaya uthi nalabo bantu bamele bafuna ukuyazi loo nto. Eyesibini into okokuba masenze isiqiniseko okokuba into enjengalena engaphinde yenzeke.
Now that aspect is more nebulous, so to speak, and maybe subtle. But it relates to something that I want to bring to the Commission, that these people who are victims have actually a right to participate in this process, almost as a self-standing right, irrespective of the outcome, irrespective of what happens, but their right to participate, to be part of the process is crucial and should not be underestimated. Now, I say that, Chairperson, because this Commission has achieved things even before, and as I say, irrespective of whatever the outcome is. The mere fact that the Commission has set, and to that I must say, particularly the way that it has been conducted by yourselves as the commissioners, has had many, well, I wouldn't say unintended, but let's say bonus outcomes already by the mere way in which the victims are treated. The very fact that on the very first day, the first thing that happened was the reading out of the names, the observance of a minute of silence, and so on. Those things were, as I say, intangible, but would have contributed a lot to what we all want to see after the Commission. Now, and I think there are moments in this Commission where that gets realized, obviously by different people at different times. But for me, that moment was yesterday, Chairperson, when the widows of the police victims and the security guards said to me, "We want you back here. We started this together, and we would like all the victims to be here." That was a moment which I think was more profound than any witness that has given evidence here. And that, Chairperson, I'm no longer going to quote to you cases. I'm going to quote that legal document called the Sowetan of today, where it is said there that, particularly quoting Mrs. Aisha Fundi, who is the lady in the black veil, widow of security, widow of guard Hassan Fundi, who was killed during the unrest, said she sympathized with the rest of those affected by the events at Marikana and wanted closure. Fundi said she wanted to hear what happened to her husband's missing organs, including his tongue and lower jaw. And she went on to explain the gruesomeness. But the point is, when they approached me and spoke to me, but also when they obviously, before that, spoke to the media, what they were saying is that for the truth to be found and for true reconciliation, everyone should be heard. And that cannot have come easy, Chairperson, because when she says that, she's saying that about the people I represent who allegedly are the people who are the killers of her husband or are associated with them, whoever those killers might be. So this commission is not an ordinary commission. It's a mini TRC, so to speak, where not only the truth but reconciliation and justice will hopefully eventuate. And that experience of talking to those widows taught me that it's possible through this commission, as I say, irrespective of the outcome, to achieve things that one could not even have dreamt of when we started. The point of that story, Chairperson, is that without the participation of the majority of the victims, those kinds of outcomes, both intended and unintended, will be lost. And that we will have finished, so to speak, quote unquote, the race, as it were, and we'll all put our books and go home and do whatever it is that we do. But we would have left a yawning gap in the real outcomes, which is reconciliation and never again having to face this.
Umhlekazi Mpofu uthi makungabi lugxatho nje apho sizawuthi ekugqibeleni sithi hayi sicibile uthi amaxhoba kuba khona kwawo apha into ebaluleke gqitha uye wayibeka ke nendlela eyenzeka ngayo le commission umhlekazi okokuba kukho izinto ezithize eziye zenziwa ngucommissioner neecommissioner zakhe eziye zaba sisifundo kwabaninzi bethu indlela abayiphethe ngayo le commission uvelano abalibonisayo namaxhoba akhona uthi enye into ke eyabasisifundo nakuyo umhlekazi Mpofu izolo ukubona ethetha na bahlolokazi abaswelekelwa ngabayeni bamapolisa nabe security indlela abakhuluma ngayo bathi nabo ngokwabo umbono bafuna okokuba wonke umuntu abe khona apha kude kuvele inyaniso ephelele ukuba kwenzeka ntoni uthi umama Fundi uyathetha kabuhlungu ngendlela umyeni wakhe onzakaliswa ngayo kwathathwa izinto ezithize zomzimba wakhe inyaniso kufanele ivele ukuze kube khona ukuxolelana nokubambisana ekugqibeleni kwethu.
Last 2 points, and I must say, Chairperson, that I had a discussion this morning again with Mrs. Funde just to explain the importance of what transpired here yesterday. The last 2 points is that the Chairperson, I would like to appeal to you who have to make this unenviable, who have this unenviable task of making this decision, to consider that, of course, a postponement application is a matter which is in your discretion, as we know, which must be exercised judicially.
Well, it sounds to me, if you forgive my saying this, is if you're now busy arguing the matter.
No.
The moment you're telling us what's in your fanning affidavit, obviously the point you want to make to us is a point that would be included in your fanning affidavit.
Yes.
You can carry on. But if it's really the peroration at the end of your argument, I think you must reserve it for the argument.
Yes, Chairperson, I appreciate that. These are literally, as I say, what if it was an affidavit, a real affidavit, I would put as concluding remarks.
Well, on that basis, please proceed.
Thank you, Chairperson. And it's simply to say, Chairperson, that at least the perception of the people that we represent is that, you know, everyone has turned their backs on them, starting from the employers, the police, some government officials or ministers, their BEE partners, and all sorts of people. But they do have confidence in this commission, as I've already indicated before. And we hope that the commission will not find itself joining that illustrious list. And we know that if they feel like that, we will be the first ones to point out that about the difficulty of the task that you have in balancing the interests of everybody. So I just wanted to assure you, Chairperson, that we will, as we've always done, ensure that whatever the outcome of the application, that it's not construed in a manner that indicates that indeed everyone has turned their back on them. And their only voice, Chairperson, even if I say so myself at this point, are the people who represent them legally, whatever the difficulties that those people face. And all they want really is a chance to have that voice continuing to be here for what it's worth. The last point, Chairperson, is that something again that happened yesterday, when one of the applicants said to me, well, if they want to continue with this without us, then they mustn't call it the Marikana Commission, because we are the people who come from Marikana, and those people who will remain there are not from Marikana. And I took it at first blush as a joke, but when I reflected later, it really said something to me about what the applicants feel should be the character or the continuing character of this commission. and this one didn't come from them, it came from me when I was thinking later, that if indeed it continues without them, then it will only be a commission of those who have the money to continue their participation. And that it would then be not the Marikana Commission, but the Manikana Commission, M-O-N-E-Y. And we don't want that to happen, Chairperson. We would like to continue with the Marikana Commission as we know it. And we appeal to you to ensure that the Marikana Commission continues after a postponement to allow us to do whatever we can to obtain legal representation for the victims, failing which, if we fail, because there's always that possibility, we'll come back and say so, Chairperson. But for now, we're very optimistic that starting where, or rather ending where I started, that either one of the two events, either the litigation or the other events, will put us back to where we should have been. Yes, we might have lost a month or so, but in the fullness of time, in 100 years' time, when historians look at this, I'm sure they will not count a couple of weeks here and a couple of weeks there. What they will count is whether or not the objectives that are on that just behind you, Chairperson, truth, restoration and justice, and I might add reconciliation, whether it was achieved or not. And it cannot be achieved without the victim's presence. Thank you, Chairperson.
Ube chaza apha umhlekazi uMpofu kokuba kweminyaka elikhulu ezayo iyoba ijenga lento masithi ke lonto ekufanele ibone ngelo xesha kuzoba into eyiqiniso. Ubegqibezela ngokuthi isicelo asenza apha kwi-chairperson ne-commission zakho uyazi ukuba yinto enzima okokuba enze isigqibo. Kodwa ke uthi uya.
Do you wish to say anything on behalf of the families who are in a stance of solidarity with the injured and arrested persons?
Indeed, Chair.
If you filed an affidavit in support of the application, what would you say? Because this is all we're concerned with at the moment. What would you say in such an affidavit, if anything?
Thank you, Chair. Chair, we do support the application to an extent that, Chair, when the first quote and unquote postponement application was brought, we were the so-called co-applicants or second applicants, Chair. Chair, I would like to send my Mr. Ntebeza's apologies again for not making it this morning. He did try to make alternative arrangements, but that did not work out. Indeed, Chair, as you also pointed out earlier on, in particular, the families of the deceased, they do have funding from the Legal Aid Board to participate or to at least continue with participating at the Commission. However, our instructions are that they cannot continue, at least they see the representation of the applicants at the Commission as very critical, at least for the families' meaningful participation at this Commission. They say this because they view the applicants as the only people who can give direct evidence as to what happened at Marikana between the 9th and the 16th of August. In particular, they see them as people who really lived to tell the tale or to tell the story as to what happened on that day. We are instructed again, Chair, to record that the families, the way as they view things, they can never achieve the peace and reconciliation that is intended through the process, as the truth about Marikana will remain unknown if the applicants do not continue participating at the Commission. They, in effect, Chair, say that their involvement, that means the family's involvement without the applicants, would essentially be meaningless, or at least be redundant without any version by the applicants. Now, Chair, I've been asked, in trying to persuade, at least to plead with you to postpone the commission, at least pending the return of the commission, to read a statement by one of the ladies of the deceased, which will be the widower, Ms. Zameka Nungu. I would therefore beg the...
This is something that you would have incorporated in an affidavit, supporting affidavit, if such an affidavit had been filed.
Indeed,
that's the
Chair.
case, you can agree to that.
Indeed, Chair. I thank you for the indulgence, Chair.
Umhlekazi apha uxhasa isicelo esesinikezwe ngumhlekazi uMpofu uthi umele bona bamele ifamily zabo abantu abonzakala phaya illegal aid uthi kodwa ke aba bantu abamele bayasho nabo ngokwabo ukuba kho kwabo ngaphandle kwaba bantu abonzakala nalaba baboshwa akunakunceda le commission ngoba phela kwabantu abanokuveza ubungqina bento eyenzakala phaya abayibona ngabo babekhona kulento bathi xa ingagqitshwa ke le commission bangekho bona obobungqina bengeke buvele into ezokwenza kokuba kungabikho uxolo kulento emva kokuba umhlekazi uMpofu eseyichazile okokuba aba bantu bayibona ngohlobo olunjani lento kokuba kukho asebabajikele ngoku uye waba umqeshi ubajikele amapolisa abajikele uhulumente nabaphathisa ababajikele bona ke ababamele ngabo kuphela okulizwe ngoku labo bantu ngaphandle kwelilizwi labo ukuba ubungqina babo abona kuvela apha uthi omnye wabo uye wathi izolo xa ethetha waphaya wathi mabayeke ukuyibiza ngeMarikana Commission le commission xa bangekho bona abantu baseMarikana mayibizwe ngecommission yabantu abanemali njengoba ethi mabayibize ukuba iMalikana emva kokuba baqothiwe bo.
Chair, just to make sure I don't lose the essence of the statement, I will read the statement as is in Ms. Nungu's words as the representative of the rest of the families, Chair.
Ufunda ngokwe-statement phaya umhlekazi uTebu into ebhalwe ngomnye wabo abantu abamele ufuna ukuyibeka ukuba ivele nayo apha kwi-report.
It says the reason we are participating in the commission and our interest in it is to find out the truth about what happened to our loved ones. We want and need to know why they were taken away from us in such a sudden and violent manner. Why our husbands, fathers, brothers, sons, and cousins, who were in most cases our only breadwinners, were shot and killed by the police. We seek the truth about what happened at Marikana primarily for 3 reasons. 1, in the hope that this will bring us some measure of healing, closure, and restoration, and thus give effect to our right to human dignity. 2, to safeguard our rights in relation to possible future civil claims against SABC for the unlawful killing of our loved ones. Our interest in this regard would clearly be impacted by the Commission's findings. Three, in the hopes of seeing those responsible for our loved ones' deaths, brought to justice. The Commission is empowered to make recommendations that specific persons be prosecuted. Mr. Mahlangu, maybe you could translate that.
Ufunda into ebhalwe apha ngizawuthi njengamafobi uthi lo obhale lento ubhale okokuba isizathu esenza ukuba bazimbandakanya nale commission ukuba bafuna ukwazi inyano okokuba intoni eyenzeka phaya kwizithandwa zabo intoni eyenza okokuba abayeni babo onyana babo nabanye bade babulawe into ebafuna ukuyazi apha inyaniso yonke ephelele kwento eyenzeka phaya eMarikana ngethemba lokuthi bazawuba noxolo emva kokuba xa ingavela inyaniso kokuba intoni eyenzeka bathi ke into bafuna ukuba lamangqina abekhona bazokwazi ukuthi buvele obubungqina ukuthi xa kuzawuthi hambeni kwexesha babe nezikhalazo iclaims abazokwenza kube buvelile obubungqina bakwenzeka ntoni.
As things stand, SABC is denying that its members acted unlawfully when they killed our loved ones. In summary, the case that SABC is advancing before the Commission is that our loved ones were charging at the police and that the police shot and killed them in self-defense and or private defense. Indeed, our loved ones have been painted as violent and brutal men who wanted to kill the police and were in a process of attempting to do so when they were shot and killed. From what we know of our loved ones and the evidence that has been presented at the Commission to date, including the video footages we have seen, the pictures, we simply don't believe this to be the case. We are of the view that they would not, that means their loved ones, they would have not have attempted to attack and kill the police. In addition, in our opinion, the video footage of the shooting does not support the SABC version.
Uyibeka ngolohlobo kokuba amapolisa ayayikhanyela into yokuba abulala ababantu ngenjongo. Baveza okokuba babulala badubula phaya bezikhusela noma bakhusela ogxa babo. Kodwa xa sijonge imifanekiso evele vezwe phambi kwale commission ayikhombi obobungqina ngokubazi bethu ke aba bantu abasweleka sibazi ngabantu bebangeke bayenze lento kokuba bahlasele amapolisa bekungebona abantu abanjalo.
The only persons who gave, at least the only persons who have given evidence to gainsay the police version are the witnesses who have testified to date on behalf of the first applicants, in particular Mr. Magidwana and Mr. Pasha. They have given an explanation as for why some of the protesters appear from the video footage of the shooting at scene 1 to be advancing in the direction of the police.
Bathi kuphela abantu abanikeza ukungqina apha obu phambi kwale commission kuMagidwane noPasha abangabo ababenza isicelo esizokuba yime iCommission abangabo abaye banikeza incazelo yokuba aba bantu bebonakala kumfanekiso engathi basiza ngapha kumapolisa kwenzeka ntoni apho.
It is only due to the evidence of Mr. Magidwana and Mr. Pasha that we have been provided with protesters' side of the story that contradicts the SABC version.
Magidwana noPasha kuphela abathe kwade kwabangoku abanikeza intetho ngahambelani nale evezwa ngamapolisa.
It was only due to these witnesses' participation that we have some understanding as to why our loved ones acted in the manner in which they did, of what they were thinking, feeling on that day, in the hours, the minutes preceding the killings.
Uthi ngabo kuphela abantu abaveza ubungqina esivayo uba yintoni leyenzeka ukuze aba basweleka benze ngolehlobo bavela ngakhona phaya kwimifanekiso nokuthi ngelo xesha bebaziva bangabantu abanjani intoni yayenzeka.
These versions relate to the central dispute in the commission, namely whether or not there were any legally acceptable justifications for the killing of our loved ones.
Lingxelo kabayivezayo iyona ekhombisa ngaphandle kokungabazo kokuba kwakukhonana isizathu esasifanele esinikeza amapolisi igunya lokuba bayenze ngalendlela benze ngayo.
These are thus two diametrically opposed versions before the Commission regarding whether SABC acted lawfully when it shot and killed our loved ones. The contrary version has come from the witnesses of the first applicants.
Lena ke iyona ingxelo ebonisa okokuba iyaphikisana nentetho evezwa ngamapolisa kulamanqina.
This to us is not surprising. They are the only party to the Commission's proceedings apart from SABC who were there and when the relevant event happened and who witnessed them. Indeed, it is safe to say that aside from the journalists who are unlikely to testify, they were the only other eyewitnesses.
Ngabo kuphela amanqina akhona asaphila akhombisa okokuba kwenzeka ntoni phaya baphikisana nale ngxelo ngaphandle kwaba bezintatheli bamaphepha babekhona apha bayibona lento esingathemba okokuba bazawubizwa njengamanqina.
It is for this reason that the first applicant's full and effective participation is crucial to our case and to legitimize the commission. Without their full and effective participation, the other side of the story cannot be told.
Siso ke sizathu esithi ngaso baleke gqithi into yokuba lamanqina abizwe abekhona apha ngoba ngaphandle kwabo inyaniso ayinawuvela.
Nor can it be said that there will be no further need for evidence from the applicants, from the first applicants.
noma kungatshiwo kokuba akusekho sidingo sokuba kubekho ubungqina obuzawuvezwa ngabo.
This is so because there are other critical issues in relation to which the first applicants will be required to give evidence if the other side of the story is to be told.
Ngoba kubaluleke gqitha okokuba babizwe bazonikeza amangqina banikeze elinye icala lalento ekuthiwa iyenzeka phaya.
I will refer to two examples of these critical issues.
Sawuveza nje amaphuzu amabini abonisa okokuba ibaluleke ngantoni lento.
The first example is the incident of the 13th of August 2012, during which 3 protesters and 2 police officers were killed.
Eyokuqala ile yesehlakalo somhla ka-13 mhla kuzawusweleka amapolisa amabili nabahlali nabaqhankqalazi.
The first applicants have not testified in relation to this incident. Major General Mpempe, the commander who was in charge of the relevant police operation on that date, is currently giving evidence. He testified that what led to the killings on that day was that the protesters suddenly changed direction while being escorted by the police and started moving in the direction of the informal settlement. This made it necessary for the police to use force in a form of tear gas, stun grenades, rubber bullets, in order to deter them from moving in that direction.
Akupho bungqina okuvela ngaba kwaba bantu ngaphandle kwentetho esiyive ngoMajor General Mpembe okungiyena wayeyikomanda engaphezulu othi ke kubungqina bakhe kuthe xa kukhashwa aba bantu basebejika besiza ngapha ngasemapoliseni apho kwadutshulwa khona i-stun grenades ne-rubber bullets.
It is common cause from the inspection in loco conducted by the Commission that the first applicants dispute this version. Their version is that they were simply on their way to the copy when they suddenly came under attack by the police.
Uthi icace lento okokuba yabonakala ngale mini siye phaya siyojonga lento okokuba babezihambela nje aba besiya phaya entabeni xa amapolisa basukela nje bahlasela ebadubula.
The applicant's version has not been given as evidence under oath as yet.
Ubungqina babo kabukaveli apha ngaphambi kwale commission kude kube ngoku.
Therefore, if the applicants are not able to participate fully and effectively, their version in this regard will not become part of the record.
Elake xa bengabizwa bangabuyi kule commission ubungqina babo abunawuvela apha kule commission njenge-record.
The contrary version will simply not be before the commission. The only way of disputing the police version will be by means of objective evidence of the incident, including the video footage of the day. There will be no one to speak on behalf of our slain loved ones.
Uthi ke xa eveza apha ubungqina obuzawuba phambi kwale commission ziivideo ezi zinqina la into ethethwa ngamapolisa kungekho bungqina obuyikhanyelayo loo nto obuvela kwaba abasweleka.
It is our respectful submission. This could never be in the interest of justice, and the outcome of the commission would not be legitimate if it were to continue in this manner.
Sibona ke thina lento kokuba xa ingenzeka ngaloo ndlela kuzobe kungenzanga bulungiswa apha ngako iziphumo zale commission sizawuba into ebeyingafuneki kuba ivele ngolo hlobo.
The second example is that of Mr. X.
Wesibini ke yilo ubizwa ngoMr X.
Mr. X, as yet, is an unidentified witness who has provided statement and who is allegedly going to give evidence on behalf of SABC.
Lo Mr. X usengaveli ke apha njengenqina kuthiwa ngumuntu owenza istatement ozawunikeza ubungqina obunceda abakwa SAPS.
He was allegedly one of the leaders of the protesters. He makes a number of allegations against the protesters, both the living and the deceased. If by the commission his evidence could lead, if accepted by the commission, his evidence could lead to adverse inferences being drawn against the protesters. For example, that the protesters were highly organized, they had a clear command structure, they were brutal in nature and committed a number of violent crimes in an organized and premeditated fashion, and that they believed themselves to be invincible, due to having used muti and undergone certain rituals with the Sangoma.
uthi umhlekazi apha xa bungamkelwa ke ubungqina bakhe lo mhlekazi uX buza kunika isithombe esingesona saba baqhankqalazi ngoba uthi aba baqhankqalazi bekungabantu ebebahlangene bekukho inkokheli ezibekiwe phaya bekungabantu abanodushe kungabantu abalwayo beyenza yonke lento benenkolelo yokuba abanokuhlulwa ngoba kuye kwasetshenziswa iyeza phaya ebalifumene kwisangoma kwaba khona amatiletile athize enziwa phaya.
In our view, the only persons who can dispute this are the first applicants, particularly those against whom he makes specific allegations.
Abantu ngokubona kwethu ke abantu abanokuyikhanyela lento abanokuyiphikisa ngaba benza esicelo sokuba lime elityala ngoba babekhona apho bazokwazi ukunikeza ubungqina bezinto ezithize ezingavezwa amaqondana nokuba zenziwe ngabo.
In addition, it will be extremely unfair to require them to do so without having legal representatives to advise and protect them. This is so.
Akunawuba into enhle okokuba abo bantu beze nje bazothetha apha banganaye obamele.
This is so because Mr. X makes specific allegations of criminal conduct against them.
Into ke ebaluleke gqitha apha kokuba lo mhlekazi uX kukho intetho ezithize azivezayo okokubenza izihlakalo zolwaphulo mthetho.
In seeking to refute these allegations, they do therefore run the risk of incriminating themselves.
Xa kunjalo aba bantu beza bona ngaphandle kwabameli bangahle bazifake engxakini apha yokuba bathweswe amatyala.
In particular, Mr. X also makes allegations of criminal conduct against one of the deceased, that being Mr. Noki.
Enye ke into ekhona uMr X uveza intetho ezithize ezolatha okokuba omnye wabantu abenza izehlakalo eziphambene nomthetho ngumfi uNoki.
Mr. Noki is Ms. Veronica Noki's partner.
O enthetha ngaye ke umama uNoki ngumfelokazi kulo wasweleka uNoki.
Accordingly, the applicants who were the witnesses to the events in question are thus the only persons who can possibly speak on Mr. Noki's behalf and dispute the allegations which Mr. X makes against him.
Ngako ke aba benza isicelo sokuba imiswe le commission ngawo nje amangqina asikhona angakwazi ukuthetha but veze ukuba ilento ithethwa ngoNoki inyani kanena inyani sona.
The applicants are thus the only party to the Commission's proceedings who can counter subversion and their degradation of their loved ones.
Aba ke benza esisicelo esiphambi kwe-commission ngawo kuphela amangqina anoveza intetho ephikisana nalithetha ngamaphoyisa eyehlisa nesidima sezithandwa zethu ezingasekhoyo.
In our view, they speak for our dead husbands, sons, fathers, brothers, uncles, and cousins.
Ngamanye ka amazwi ngabo ebesengumlomo ngokubelilizwi labayeni bethu abasweleka amadodana otata izizalwane zethu omalume nabanye.
If they are not able to participate fully and effectively, we will be forced to sit and listen to their version with no witness to counter it.
Abangavunyelako kokuba babe khona banikezwe igunya lokuba khona sobe silalele intetho eveza ngabanye kungekho umuntu oyikhanyelayo.
Our participation in the commission will thus be rendered meaningless and redundant.
Ukuba kho kwethu kule commission ke kuzawuba nje yize.
Rather than enabling the family members to achieve some measure of healing and restoration, this will only add to our pain, unbearably so.
Endaweni yokuthi i-commission lena ikwazi ukusithoba amanxeba ukuthi kube khona nobuyelelwano iza kongeza inhlungu esikuzo.
In addition, in our respectful view, such one-sided commission will not have any legitimacy. We simply could not take part in it.
Ngokubona kwethu ke noyengenhlonipho siyitsho lento kokuba i-commission njengaleyo izawubonakala njenge-commission ethatha icala elinye ngako ingezokuba nentembeko apho singafuneki ukuba sibe apho sibona ukuba asiza kuba angeke sibe khona.
Thus, in conclusion, if the applicants are not unable to participate fully and effectively in the Commission's proceedings, the consequences for the family members will be devastating.
Sitsho kokuba apha ekugqibeleni abangavunyelwa okokuba babe khona apha iziphumelo zale commission kuzawuba into ezeneze kwiifamily nezihlobo.
This will be devastating because our rights to restorative justice, which is an incident of the right to human dignity, will be infringed.
Sibona apha ke kunyathelwa amagunya namalungelo esinawo.
It will be a violation of our loved ones' right to life because we will be deprived of their right to participate in the state-appointed Commission of Inquiry into our loved ones' deaths in order to safeguard our rights and legitimate interests.
Eso kuzoba sisenzo esinyathela amalungelo empilo alaba basweleka izithandwa zethu.
The civil claims which we intend to institute against the state may be prejudiced.
Izicelo esifuna ukuzenza sijongene namapolisa ii-claims ziza zonakaliswe ngokungabi khona kwalobo bungqina.
And finally, we will be deprived of our best opportunity of ensuring that those who killed our loved ones are brought to justice.
Enye into ke sizobe sophuca igunya lokokuba aba benza ezi zinto bakwazi ukujongana nengalo yomthetho.
Chair, that's the end of the statement by Ms. Nungu.
Phelela apho istatement sikamama uNungu.
Chair, as it's also known that SERI also represents AMCU, I put on record that AMCU does support the stance, at least the postponed applications, and obviously based on the reasons as submitted by the families.
Mandiveze ke lento yokuba no AMCU uxhasana nesicelo nalendlela siyibona ngayo.
And further, AMCU regarded as it will be very difficult for itself to be involved in the commission and not to be seen to support its members, of which the majority of the applicants are its members. For those reasons, they also support the postponed application.
Ithi AMCU ibona kunobunzima ejongene nabo kokuba yona ibekho kule commission apho amalunga ubuninzi babantu ababenza isicelo bangamalungu abo bangamelwe.
I thank you, Chair.
Enkosi.
Well, what has been said will be transcribed. I'm told it will be available at 9 o'clock tomorrow morning. It will be given to the evidence leaders who will then send it electronically to all the parties. As I've indicated, the Department of Justice and Constitutional Development wishes to oppose the application also and be made available to them as well. And maybe that locus standi points may be raised, but clearly we will send the transcript to them. Thank you very much. I think we'll take a short... Sorry, Mr.
Uthi umhlekazi yonke lento ibithethwa apha izawubhalwa ngokishicilelwe kuthi ngomso inikezwe kwi-evidence leaders zikwazi ukuba ithumele kuwo onke amaqela nakumnyango wezobulungisa. Umnyango wezobulungisa nawo uthe ufuna ukuyichasa lento uyayichasa uchasene nalesi sicelo esenziwa apha.
Chair, could I just ask for clarity on one aspect of the relief which is being sought in the application? Mr. Mpofu has explained that this is an application for a postponement pending the attainment of funding from private sources or the outcome of the pending application in the High Court, whichever comes first. Can I just ask for clarity on what is intended by the outcome of the High Court application? Does that include the outcome of any appeal which follows on the decision of the High Court?
Mr. Mpofu?
Thank you, Chairperson. Yes, that's a fair question. No, it does not. As I indicated, maybe not clearly, we're talking about the outcome in the first instance. In other words, we would assume to ourselves a duty to come back at that stage of the outcome of the first instance. We would not simply hide behind the word outcome and say, well, it's the final outcome. I'd like to place that on record. Thank you, Mr. Butland.
Thank you. I think that makes the point clear, Mr. Butland.
Ubethi umhlekazi Mpofu emva kokuba umhlekazi uButland.
I understand that Mr. Semenya, am I correct? Semenya wishes to say something, and there may be others who wish to say something as well.
Umhlekazi uSimenya andazi nabanye kuba mhlamba banentetho bona emva kwayo yonke lento.
Not anymore, Chair. Thank you.
uthi
Mr.
uyabulela
Sikota?
umhlekazi Siminyaka
Thank you,
nentetho.
Chair. Now that we've had the privilege of being apprised of the basis and the foundation of on which the application, the request by Mr. Mpofu stands, I beg to record on behalf of NUM that we will not be opposing the application. In fact, we will abide the ruling of the Commission regarding the request.
Yes, thank you. That can be
Uveza ukuthi emva kokuba yena omele inum bayivile ngokugcwele lento evezwa ngumhlekazi Mpofu uthi abana kuyichasa lento baza kuzibeka nabo esigwebeni kwisigwebo esizokwenziwa iCommission bazawahambelana nazo.
Is there anybody else who wishes to say anything before we conclude this part of the proceedings?
Buzo umhlekazi ukuba kusekhona omnye othanda ukuveza enye into ngaphambi kokuba.
It doesn't seem so. So I think we'll take a short adjournment now. It's 12:20. We'll carry on with our normal work for the time being. Mr. Mpofu and his party are excused, but we'll adjourn to enable them to make a dignified departure, and also, of course, to enable Mr. General Mpembe to be requested to come. I don't know if he's in the building or wherever he is, but we'll take an adjournment and we'll resume when we are told that it's appropriate for us to do so.
Chairperson, thank you. I just wanted to say thank you for giving us a hearing. We appreciate it. Thank you, John.
Emva kokuba umhlekazi Mpofu nalaba hamba nabo bevunyelwa ukuba bangaphuma. Commission commences masukumen sonke.
Correct, Chairperson. What I wanted to achieve or to end the negotiation on that day was on the fact that since the protesters were having the dangerous weapons, the win-win situation that I spoke about, it was with reference to if they can drop their dangerous weapons, because that to me was extremely important, because that is what they can use to maim or kill people. I know that them possessing the dangerous weapons was against the law, and I know that they were not marching legally, but that to me, when I compare it with the situation, I find only for them to lay down their weapons and to allow them to march, that could have be in a better position for them. And that could have been a win-win in the sense that the laying of downs of weapons, it could have been a win to me, because that is what I targeted. And for them to have marched where they wanted to go, it could have assisted to de-escalate the violence.
Okona nijongile uba kuzoba impumelelo ngalomini xa nandithetha nabo kwauba ubani banokwenza babeke phansi izixhobo zabo ezinobungozi ndandizokwazi ukubavumela bamatshe baye kuloo ndawo babesiya kuyo. Loo nto yayizowenza uba udlame lwalapho luwehle kancane.
General, just to round up this point, I just want to put to you what was the evidence of the Reverend Sioka, who was asked, was being cross-examined by Mr. Nsebeza, and on the basis that he's an expert in conflict resolution within a mining context. And he was asked to comment on the, in brackets, negotiation, in inverted commas, the negotiation that you undertook on the 13th at the railway line. Now, I've asked for copies of the relevant portions of the transcript to be made. If I can just... It's day 18 of the transcript. 1-8.
Asingayisibheke phaa kulaa suku lweshumi nesibhozo kunengqini nalibuzwa ngomnumzana uNtsebeza singake sibheke kulo ubungqini labunikayo.
At page 2002. Now, I'll just read to you, General, what the question from Mr. Nsebeza was and what the Reverend Sioka's answer to the question was. And Mr. Nsebeza says, not very long, Mr. Chairman, you know I keep my promises. Now, in fact, as it is, just for the record, the witness has said in paragraph 3 of his statement, he has specialized knowledge of and experience in conflict in the mining industry. Now, I was asking you for your views on, given the volatile nature of that situation as you see it on the video, what do you think of General Mpembe's reaction to what seems to be a proposition in a tense situation? Now, just for context, General, the video he's referring to is Z1. And the answer by Reverend Sioka is, I think it was a desperate, unprofessional way of handling a situation that could explode at any time, as he assumed. If I were him, I would have handled it differently. Mr. Nsibeza says, yes, I will not go into how you would have dealt with it. If I heard him correctly or clearly, he began to count even as Polani or the worker was beginning to talk to him. He says, I am now counting. Like, listen, you hand over. It's my way or the highway. Did you observe that? When he said, I am counting. And the Reverend Sioka's answer is, that's an indication of being impatient and threatening, really. If I count this number and have not done what I've asked of you, I will do something. That's my assumption. Can I ask you just to comment on Reverend Sioka's analysis of what you did on the day?
Ungake uchaze mhlambe general owakwenzayo ngalomini njengoba ube ufunelwa phaya.
Chairperson, it's true that the situation was tense. And I need to indicate that the negotiation that took place at the railway was not a normal negotiation where the environment, which is very conducive, is prepared, all strategies are being applied. I can make an example of all conflict resolutions that they have been dealt with, where you put the environment in a proper manner and the approaches are being determined. Parties are not hostile to each other. Secondly, in that circumstances, taking the background of what has happened on the previous day, and I did say that I did not know who were busy killing and who were doing any other when I started speaking to them.
Ndingatsho ndithi ngalomini imo yayemaxongo kakhulu yayingafani nezimo apho ube unolwazi ime uyilungiselele ulungise ngayo yonke indlela efanele uyenza.
The protesters were carrying extremely dangerous weapons. And the manner in which, and the song that they sang that day, is not a song that is normally, or the weapons that are normally being carried in any conflict resolution processes that I have ever seen or understand. Which may be in the case of Reverend Walker that he knows himself. And secondly, and what was also very crucial, in as much as myself, I was realizing that by allowing them to march, it's still against the law. I had also to look at the compromise of the dangerous weapons, because the dangerous weapons was what was actually being utilized to commit all the crimes that were happening. Even though I did not know who in particular amongst the protesters was committing crime, but it could have been that they were amongst those protesters. But what was more crucial for me is if they could lay down their weapons, and in laying down their weapons, then we will, and we could have avoided a lot of the damages that has happened. And what was very crucial for me in that instance, in terms of the police crowd management policies and conflict resolution, we have to show an extreme tolerance to the protesters. However vulgar words or any other weapons or any other action that they could do, because there were so many provocative actions that were coming from the protesters, but I keep the members to be tolerant because I could see the situation could have gone either way.
Imeko ngalomini emaxongo kakhulu kwaye nezixhobo owaziziphethe zazingaqhelekanga kwimo esiqhele ukujongana nazo, kwaye nengoma ababeyicula ngalomini kwaye ngengoma abaqhele ukucula xa kunemidibano enjengaleyo.
As I have indicated, I had to get dangerous weapons. So at a certain point, I had to put them to comply. And I need to say, in any country where a senior police official requested any responsible citizen to hand over a dangerous weapon, that is all what I expected on that day. And that could not have happened.
eyona ndandiyifune ngamandla kwauba babeke phansi izixhobo zabo ezinobungozi kwaye njengoba ndandisitshilo nakuqala uba nakweliphi na ilizwe xa upolisa licela ummi welizwe othembekileyo uba abeke phansi izixhobo baye bayenze njalo bazibeke izixhobo yona ndandiyijonga kakhulu uba babeke phansi izixhobo bakwazi ukuba bahambe bayapho babeya khona.
Now we see at line 13 of page 2002, General, that Reverend Sioka describes your way of handling the situation as both desperate and unprofessional. And he says that he could have handled it differently. Did you consider at the time, General, that there may have been different ways of handling the negotiations so that you could get the miners to hand over their weapons?
Ingaba general wakwacinga mhlawumbe kwaukhona indlela engenye ongawungenza ngayo mhlawumbe ukubazama ukubacenga babebeke phansi izixhobo engafani nale wenza ngayo.
Chairperson, on that day, as a senior police official, I felt that, as I have explained already in Triple H3, that I could handle the matter also in a manner of, for example, asking one of their two or what of their representatives to talk to me to negotiate. But in the manner that they were acting themselves, you could see that they could not have allowed, there was no element of trust. There was no element of trust. They could not have allowed anybody to go and negotiate, allow them to go and negotiate with me, because they were feeling that they wanted to go with weapons. Secondly, I could not have changed the environment in any way to be conducive, because what was more important, it was to disarm them, and that is what they could not have allowed me to have done, as they did on that day.
Indlela engandinokwenza ngayo kwakuba ndicele omnye wabo okanye ababini babo ndize ndizothetha nabo kodwa ngendlela kwakume ngayo ngaloo mini babengenawuvumela omnye azokwazi ukuthetha nabo kuba bona babezimisela uba bahambe nezixhobo zabo kuyinto eleyo ndandizama ukuyicela uba bashiye izixhobo zabo.
Comparatively speaking, on the following day, on the 14th, when we were now going to negotiate with them, that was the negotiation that was done, initiated by the police. The 5 brave Madoda were asked to negotiate. They were put at ease. They requested that we should bring Umlungu. And I need just to indicate, they asked that we should bring Umlungu on the 13th. I did that. It's the South African Police Service that initiated the negotiation between the unions and the mine. That could not have happened if the police did not take the initiative. Secondly, on the following day, because those were the alternatives after what had happened on the 13th, when we said we have to continue, because to us negotiation, it was the extremely better position of ending up the conflict on that day. That's why then we continued with the negotiation. 5 brave Madoda were called. On that day, they requested to see Umlungu through Colonel McIntosh. Myself, Colonel McIntosh, and now Colonel Mulman. We went to the Lonmin management. We said, the protesters, they still want to see you. That message is conveyed to the Lonmin management. And my witnesses in this case is Colonel McIntosh, as well as Mulman can confirm that. Colonel McIntosh, and I think in his statement, does state it. I need just to demonstrate the alternatives that one could have done depending on different circumstances and the situations that were changing from time to time.
Njengomeko ezehlukahlukayo ngosuku olulandelayo lasuku lwange-14 kwaye kwacelwa amadoda amahlanu uba ayize ngaphambili azokwazi ukuthethela icela elo aye afika nayo akwazi ukucela umqeshi wawo kwaye thina njengamapolisa kwelo thethathethwano sayenza inzame uba umqeshi wabo aze azoba khona apha kungangqina no-Colonel McIntosh kwaye no-Colonel Mulman kuba sithi thina amapolisa esenzayo uba aze umqeshi wabo bazokwazi ukuba khona uthethathethwano.
Chairperson, I need to add that we were extremely considerate in terms of whatever they were requesting. There was a time where they wanted my telephone numbers, and I said they need to come to the JOC. And that their advocate, Shapiro of Pretoria, wants to talk to me. The information was conveyed to them many times to say, the general is now at the JOC. He wants to talk to you. So any person could have come there. And secondly, Colonel McIntosh did check who's this advocate Shapiro, and we could not find and establish who is this advocate Shapiro.
Sasibacingela kakhulu kuba sasikwazi ukuzama ngandlela zonke kuba sibe nalo thethathethano labo kangoba nefone number babeyifunile sakwazi ukubanika baye baveza nabo uba kukhona uadvocate uShapiro wasePitori owayefuna naye ukuthetha sazama ukufumanisa uba ngubani nalo advocate Shapiro.
In ending my answer, it will be that in what Reverend Walker is referring, in terms of the police on that day, I do not know whether he was referring to a normal process of negotiation. Like, if I may give an example, you could do that if the environment is conducive, like the negotiation that was done between what was happening at Galaka Estate, but or in any place where negotiation has to take place. But there, it has, I am a law enforcer. I need to enforce the law of the country. I need also to ensure that the people, whenever they march peacefully unarmed. But I do believe that we did what we could to persuade and to negotiate with the protesters on that day.
Andazi ke ungaba umnumzana Walker uthetha ebhekiselele ukuthethathethwano olunjani apho mhlambi imo ezivumelana uba kube khona uthethathethwano oluhamba ngokwesisekelo lwaso njenga mhlambi uthethathethwano olwake lakhona eGalaka Estate kodwa kulemo sasikuyo sazama nganzame zonke esinako uba kube khona uthethathethwano olukhona.
I'm sorry to interrupt. Can I ask you, do you know whether Advocate Shapiro's telephone number was ever furnished to you or to any other member of the SAPS?
Ingaba unolwazi uba amafoni number ka Advocate Shapiro aye anikezwa elinye ipolisa okanye wena?
Chairperson, they were not given, but I tasked Colonel McIntosh to follow this Advocate Shapiro. He had one Advocate Shapiro that he knew, and he followed it up with him, and then he said it's not him. The one that he found, he was dealing with actually the divorces. He was not actually, and he said that he's not of his lawyer. He didn't know which Advocate Shapiro that they were referring to.
Azange sifumaneke izo number kwaye ndaenda xelela umnumzana McIntosh ba ayilandelele lento leka mnumzana uShapiro wazama wafuna omnye umnumzana uShapiro wafumanisa ba yena ligqwetha lo lezohlukaniso ayinguye lo osebenza ngalento okuthethwa ngayo.
Mr. Blair, are you going to ask any questions about Lonman's response to this request? Because if you are, I won't ask any questions about it.
No, you could ask. Good.
You said you and Colonel McIntosh and Captain Millman, as he then was, went to see Lonman to convey what you mentioned to us, the request of the strikers. Did you speak to people at Lonman about that?
Ubisichazela uba wena no Colonel McIntosh no Captain Mulman naye eLonmini niyodlulisa isicelo eso sokuba bafuna ukubona umqashi ingaba nathetha nabantu abathile eLonmini?
Chairperson, we did go and talk with Lonmin people, and I think Colonel McIntosh will confirm, and Colonel Mulman.
To whom did you speak at Loma?
I did, Chairperson.
To whom?
We did speak to, at that time, one member was Mr. Sinclair. He was also having, the gentleman is A.B. Khotle. But I think it's A.B. Khotle. And then it was on the early morning, if I remember very well, of the 15th. That was before that meeting which I was supposed to hold with the unions later. And then they said, we will get the answer. Now, and it was also at that time that I emphasized to them to say, then I need also to get the unions. So, Chairperson, then the answer which I got the answer which was recorded at the exhibit 004.
Ewe lo mina sakwazi ukuthetha nomnumzana uKhohle nomnye ogxa wakhe apha kulapho naye ndacacisa uba sifuna nokubona nama union ingxelo leyo yabhalwa phansi ku exhibit 004.
General, there's a further dimension to what I've been putting to you, and it's a contention that was advanced both on behalf of the miners and on behalf of the families. And that is this, that the police had at their disposal a seasoned and experienced negotiator who had experience with conflict resolution in a mining context, who was a man of God, trusted by the miners. And on two occasions, or specifically on the 16th, but also in relation to the 13th, he could have been used as a resource to negotiate with the miners. Now, what's your response to that?
Captain, kukho ingxelo esiva uba kuni nani naye umakade bona okwaziyo kwezothethathethwano kakhulu kwindaba ezidibene nasezimayini kwaye ekwangumuntu wakwalizwi. Ingaba uthini kulo ndawo?
Chairperson, according to the statement of Colonel McIntosh, the people are the ones that actually couldn't want to continue with the negotiations any further.
Ngokuya ngengxelo ka Colonel McIntosh ngabantu ababengazimiselanga uba baqhubeleke nothethathethwano.
Maybe we should actually check the statement of Colonel McIntosh, because he does put it clearly what happened on the 16th.
Uba singaye sijonge phaa kwi-statement sika McIntosh nguye oyicacisa kakuhle uba kwenzekani nangala mhla we-16.
Perhaps Ms. Pillay wants to know why the police did not use someone who comes with the reputation that the Reverend Sioko has of dealing with these situations. Why did the police not elect to use him in any of the negotiations?
Commissioner Hamrat ucacisa kakuhle umbuzo ka Ms. Pillay uba ufuna uqonda uba kutheni ningazange nikhethe ukusebenzisa lo unamava ukuthethathethwano.
As far as my recollection is concerned, we did utilize Colonel McIntosh, and he has a good experience.
No, that's not the question. The question is, Colonel McIntosh did his best, but then the Right Reverend Bishop Sioko arrives on the scene. He's an experienced person facilitating and negotiating and so on. And as we know, he subsequently assisted materially in bringing about the peace accord, facilitating the arrangements that took place subsequently after the 16th. Made a very important contribution, as I understand. Now, the question you're being asked is, why didn't you take advantage of his willingness to be involved? I think that's the question. Is that right, Ms. Pillay?
That's correct, Chief.
Umbuzo obuzwa uba ngoba wayikhona nje umfundisi onamava kwaye ethembakele ebantwini ukwenzeni oluthethathethwano kuthena ningazange nisebenzise yena ewe siyavuma Colonel McIntosh wenza kangangokwanako kodwa kutheni ningazange nisebenzise umfundisi?
Thanks, Chairperson. I didn't understand the question.
That's why I clarified.
Yes. Chairperson, and I think Reverend Walker can confirm. I did not know about Reverend Walker at all. The second part that I need also to mention is, Chairperson and the Commission, you'll recall in terms of my pleading with all the leaders of the unions, in as far as Triple G4 is concerned. Because if Reverend Walker was known by one of those leaders and he was introduced, because I even told them that we need somebody that will have to bring change. So if, for example, I could see now, with the benefit of hindsight, that he's actually very close to Mr. Matonjo. If by then he was there, then we could have utilized him. But myself as an overall commander, I did not know about his services at that time.
I understand that. And to be fair, I don't think he was close to Mr. Matunzu at that stage. It was only subsequently when he came in and facilitated what amounted to a settlement. But that was all after the 16th. So I understand your answer. Is this an appropriate stage for us to take the lunch adjournment?
Yes, Chair.
Can you give us an indication, Ms. Pillay, I know it's difficult, how longer you're likely to be when we resume with the witness?
Chair, a maximum of an hour.
All right. We'll bear that in mind. We now take the lunch adjournment. We resume at 1:45.
Lixesha lelidla so kuya ngo 1:45.